You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 81. What is a supplemental examination and why would I want one? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. The past 4 episodes I talked about were 4 different procedures to invalidate someone else's patent at the patent office. These were ex-parte reexaminations, inter-partes reviews, post-grant reviews, and covered business method patent reviews. What I'm talking about in this episode is something called a supplemental examination, which was somewhat similar to the ones I talked about before, but instead of you filing a petition to invalidate someone else's patent, what you're doing is filing a petition to have your own patent be examined. In a way, there are similarities to a reissue patent application, and I'll go over those a little bit later in the episode. A reissue patent is, if you remember, if you feel you made some kind of mistake in your original patent and you want the patent office to reissue that patent to correct for your mistakes, usually in broadening or narrowing your claims. Now, you might be thinking, why would I want the patent office to examine my patent again? I got a patent and now I'm telling them, hold on, maybe you shouldn't have given me a patent. Take another look at it with these new references and make sure you issued it correctly. Now, the main reason why you'd want to consider a supplemental examination is to avoid what's called inequitable conduct. Inequitable conduct is when the patent office feels that you lied or did some other kind of fraudulent activity to get your patent issued. And that can be real bad because your patent can be unenforceable. Now, when you first apply for your patent in the application, you're required to disclose information you know that might be material and relevant to you getting a patent. If you know there's something similar out there, you have to disclose it to the patent office. Now, there's no requirement that you actually search out similar things and present them to the patent office. It's only if you know about it already. Then you have to disclose it, and you do that in an information disclosure statement, which I had an episode about. Now, you're required to submit anything that you know about that might have been material and relevant up until your patent issues. Once your patent issues, you don't have that requirement anymore. So let's say the day after your patent issues, you come across something and you think it may have changed the examiner's mind about giving you a patent. There's actually no requirement or duty that you have to inform the patent office about this after your patent issues. But if you know about some references and maybe you forgot to disclose it or you didn't disclose it on purpose, you don't want that to come back and haunt you, because if someone proves that you knew about something but didn't disclose it to the patent office, that's considered inequitable conduct and it can make your patent unenforceable. So what do you do to actually prove that you didn't lie or conduct some fraudulent activity with the patent office to get your patent? The main reason you would do this is if you found some reference that maybe you knew about, but you didn't think it was that important for the patentability of your invention, but now you think maybe it would have been, and you're afraid that if someone tries to invalidate your patent, they're going to bring up that you hid this reference from the patent office to get your patent allowed. There may be other things in the record or that aren't in the record that maybe you're kind of in a gray zone that you had knowledge of. Maybe there was a way that you explained a reference that was in a foreign language that wasn't 100% correct. And you just want to come clean and not say that you shouldn't get a patent, but say, by the way, I know I got a patent, but I think the patent office should be aware of this other reference or this other information. Please consider it and tell me if I should still have my patent or not. And that way no one can say that you weren't forthcoming in presenting everything truthfully to the patent office. I talked about how this has some similarities to a reissue patent application, which I talked about before in a different episode. Now, one difference in a reissue versus a supplemental examination is that in a reissue, you're actually changing your claims to say that your invention is something a little bit different from what you got in your original patent. In a supplemental examination, in this one, you don't have to change your claims. You just want the patent office to take another look at it. If you just did a reissue, that by itself cannot cure the inequitable conduct by itself. But there have been some cases and interpretations that a reissue application could fix up some of these issues. So you do have an option of possibly doing one or the other, and you should discuss this with your patent attorney if you think there's information that maybe you should have revealed to the patent office, but you didn't do that initially. So how does a supplemental examination work? You file a request for a supplemental examination to consider, reconsider, or correct information believed to be relevant to the patent. Then, within 3 months of the request, the Patent Office has to issue a certificate indicating whether the information presented raises a substantial new question of patentability. If the answer is no, then great, your patent is still valid, and now you have evidence that you didn't try to hide anything from the Patent Office about the patentability of your invention. And even if you did hide it in the past, it's moot because the Patent Office is aware of it now, and that information made no difference to the patentability of your invention. But if the answer is yes, that you did raise a substantial new question of patentability, then you go on to the next step, which is an ex parte reexamination. And you shall listen to the episode on ex parte reexaminations. Basically, what would happen is that the Patent Office issues some kind of rejection based on the new information that you provided. And then you can argue, like any other office action, that you should still get a patent. A couple advantages of supplemental examinations are that you don't have to admit any defect in your patent when you request a supplemental examination. You can say that your patent is still 100% fine the way it is, and you just want the Patent Office to be aware of this other reference that it might not have been aware of. Another advantage is that you're preempting someone from saying that there was inequitable conduct by you because you're showing this reference to the Patent Office now, even though it's technically after your patent was issued. And if you did a supplemental examination and the Patent Office gives you the okay the second time around, other people might think twice about trying to invalidate your patent. You got it allowed the first time, and then you had the Patent Office review it a second time, and it still was allowed. So infringers might think twice about trying to spend their own time and money to get your patent invalidated. Another advantage is that you should get a decision within 3 months of your supplemental examination, which is a shorter time than if you did a reissue. One disadvantage is that it's more costly compared to a reissue. Reissue applications will probably be a few $100s in Patent Office fees. There can always, there are going to be attorney's fees as well. But for a small company to request a supplemental examination, it's currently $2,200. And if it leads to a re-examination being ordered, it's going to cost another about $6,000, and even more if you're a large company. And it would be a little less, but still thousands of dollars if you're a micro entity. So you also want to always check the latest patent fees on the Patent Office website. If you want a kind of rule of thumb for which to do, and this is a big generalization, is that a supplemental examination should be used if you want to make sure your patent is okay to enforce, and a reissue is good if you want to fix problems in your patent. But there are all kinds of costs and benefits, both in real dollars and strategies, and knowing what's best in your situation. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, you can contact me through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or email me at adam@diamondpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.